urge that in every country, prosecutors must use those tools very widely because they exist even in other legislations like drug trafficking legislation, human trafficking legislation, how do we call this one? The one of copyright and smuggling. They all have provisions for asset forfeiture and confiscation, but because all of us are looking at money laundering, we are underutilizing the tool. Secondly, we all know that what is subject to asset forfeiture and confiscation is defined. So we have profits, we have proceeds, we have benefits, we have instruments, we have gifts. What is the challenge? When the prosecutor and the investigator do not agree on what you are going to court for, asset forfeiture and confiscation, then you will not succeed. Because you have to be sure that if it is a profit, then it has to be profit of crime. If it is proceeds, it is proceeds of crime. And you have to prove that there was a crime. If it is benefit, it is benefit of crime. If it is an instrument, it is an instrument of crime. And if it is a gift, it is a gift that flows from crime. So the difficulty here is that many times you find investigators conclude their investigations before you agree on which area you are going to attack in terms of asset forfeiture and confiscation. And this is important if we take the example of wildlife, for example. We have several players, and the value is different throughout the chain. For example, we have the poacher, who uses a bullet worth maybe $30, $20 to kill an elephant, and we all know that he cannot afford that bullet, somebody must have given it to him. They also transport what they poach. This person has received very little money sometimes for an elephant or for a pangolin, and if you're going to follow that person, you lose a lot of resources, but he's just a foot soldier. Then we have the organizers who pull, they're called the pullers. These pullers, they organize by looking for the markets and looking for the sources. Now, these people use, digital communication to get the markets and also to get the products. These organizers, most of the time, will not have the product because they would have sent it. Their communication is encrypted. For that reason, it is very difficult to investigate them and to identify them. Then we have the transporters. For example, pangolin mostly are transported by air and ivory is by sea. These people use legitimate means of transportation. Now, the transporter is really targeted when we come to wildlife trafficking, when we come to asset forfeiture and confiscation. Rarely have you had a shipping company or an agent being taken to court together with a poacher for asset forfeiture and confiscation. So I think as the prosecutors and investigators, we also have to target other than the poacher, the organizers and the transporters. Then we have the consumers. And these consumers mostly are several miles away. For example, those who consume from the East African region and from the South African region are in Asia. For example, Vietnam, China, Thailand. Now, to get the consumers is very difficult. You need a lot of international cooperation, mutual legal assistance. And this is one area where prosecutors and investigators get a problem because by the time you complete the investigations, you cannot wait until you complete the investigations to take these people to court. And even if you wanted to, they are not within your jurisdiction. So how are you going to follow the money with these consumers? Now that they are even using mobile platforms to pay themselves, they can use cryptocurrencies and virtual assets. Some of the wallets are personal and individual. You can never reach to them. So that is a challenge. That was number 2. The third challenge is that most of these offenses converge, as our previous speaker said on Zoom. For example, we see ivory from Congo converging with arms and timber sale. There is a case in 2015 where timber was transported from Congo to some country in Asia, and inside the timber they made things like coffins, and inside them were ivory, almost 9 tons. Now you can imagine that is a whole industry. Somebody employed people to log, to make the timber, to bring the ivory, to camouflage them, and yet they could not be detected until they were at the seaport. And that shows you that if we were very careful, then we would find many offenses being committed along the way. We have a convergence of diamond and ivory. That is diamond from Congo, diamond from Botswana. We have a convergence of copper and ivory. There is human trafficking and wildlife trafficking. There is a case in Tanzania where somebody who trafficked ivory was paid back by prostitutes being sent back to Tanzania. And on that note, I want to just bring out one big challenge that some of the profits, some of the interactions are trade-based. Therefore, you cannot identify the money, or the money will not be tangible. Because if I send you ivory and you send back cars, or you send back second-hand clothes, or you send back prostitutes, the prosecutor and the investigator have got nothing to attach, and you can see the difficulty. We also have cases where traffickers, wildlife traffickers, converge with drug traffickers. We have a case in Kenya where we had a wildlife trafficker who had been arrested. He was charged, he was supposed to be prosecuted, and he disappeared for some time. When he was arrested from a house of a drug baron. That shows you that there is a convergence between wildlife trafficking and drug trafficking, because for them to be business associates, to share businesses and addresses, they must be working together. So the other aspect that has been spoken about is corruption. I spoke about the poacher in the forest who is given maybe $20 and is given a bullet worth $30 to kill an elephant. This is all corruption, because somebody must have allowed the poacher to go into the the game park, or to cross the gate, and somebody must have allowed them to transport them out of the game park or wherever it is, to where they are being parked. We also have immigration and tax evasion. At the immigration offices or at the borders, our border officers, there must be some kind of corruption, because how do these people manage to pack and transport ivory, even if it is camouflaged? We have sniffer dogs, we have CCTV scanners. What is happening at the borders? It must be corruption.
Finish all the investigation, then you send back the investigators to the field to go and also investigate the asset. At most, we should be investigated together at the same time. Actually, even the asset investigation should go faster than the crime. And she also talked about the target, the vehicles of crime. We should target even the consumers. I had not thought of that. We should target everyone along the chain. We don't leave anyone behind. That's when we shall say zero tolerance to corruption. Then human trafficking mixed with wildlife trafficking, very difficult for prosecutors to follow that up. You know, it is easier for us to follow the money, paper trail in the bank and all that. When it goes digital, then we are lost. Now again, it goes to wildlife and then human trafficking. It is even more difficult. What do you attach? And then wildlife traffickers and drug traffickers, a very unholy alliance. And that is something that our antennas should go up when we find such. And then when do you pick, especially for jurisdictions which have criminal forfeiture, civil forfeiture, they have administrative, you are lost for choice. Who benefits from all this confusion as you're still trying to see which one to follow? It is the criminals. So I think the indecision also follows. And then, of course, you ended it with corruption plays a very big role in all this. Corruption is actually the fuel to corruption. It is just, it goes round and round. So thank you so much, Dorcas, for that. And now I will ask someone to even monitor the online participants. If they have any questions, please, and you bring it to us. I don't know who is monitoring the online participants. Please do it for us. We have saved some time. Now the floor is open. You can ask questions, you can make contributions, you can seek for clarifications. Thank you so much. Who goes first? Yes, please, Honorable. My brother from South Sudan.
Thank you. Thank you very much. I think my colleague covered a lot of question and clarification in our minds. especially in our case in South Sudan, that we need mutual legal assistance and extraditions, because we don't have extradition or mutual legal assistance between us and our neighbor countries. And most of cases come from either from our neighbors to our country due to sub border. Most cases were smuggled either by land, and then it is to be smuggled through our airport in South Sudan, in Juba especially. 2 cases were detected. One is of elephant tusks, like 90 elephant tusks were transported from one of our neighbors here, and then were discovered in Juba airport. And then the heads of those criminals were still arrested or to be investigated due to this mutual legal assistance. The second case is a case of drugs, which is now before our courts. It is a case of drugs smuggled through one of our borders by land, and then it were headed to Europe. That the criminal use these adapters or electricity adapters with solars. They pick out all the content of electricity, adapt it, and then they load it with heroines. These heroines, when they took it to the border that they are going to transport it abroad, the one of the employees in the airport discovered that the weight of the electricity adapter is not like the weight of the usual one, which is very heavy. This one is very light. So he asked them what is inside, and then he said that this adapter or electricity adapter. Then when they opened it, they found heroines inside that weighed 26 kilo heroines. And then Sudan cooperated with us in terms to examine whether it is heroin or not, so that Sudan always cooperated with us without mutual legal assistance or what, but in the good cooperation with us, and then we came from them. Also, another case, or the third case, is the case of the corruption. We tackled it in 2015 concerning corruptions in one of our institutions. And then there were forgeries of signatures and the other receiving items which are not delivered to the office. To proceed with that investigation, we need to find whether it is the genuine signatures or not. Then we tried to send it to Rwanda through the cooperation between police to police, that we have cooperation between the Inspector General of Police of East Africa. Then on that they wrote to Rwanda, and then Rwanda accepted, and then we send all the exhibits, and they examine, and they got at the result, and even we demand from them to the expert to be testified before our court, and they did it, that one, and that is a good system. So also we have FIUS, that is Financial Intelligence Unit. That Financial Intelligence Unit, it is a committee formed within our institution in South Sudan to cooperate to each other, to follow with the money exactly where they are. And this committee is now operating. Thank you.
Thank you so much, my brother, for that. I think that was just adding on and re-emphasizing the fact of cooperation. And of course, you talked about the Financial Intelligence Authority. It's a very good source if it is in your jurisdiction. Actually, when you're following the money, you should first go to your financial intelligence authority, start from there. They normally have very good information for you to start with. And of course, also intelligence, if you have some intelligence bodies in your country, that's also where to start from, because now some of the crimes you actually get from intelligence. They say intelligence-led investigations other than prosecution-led investigations. So thank you so much, my brother. Any other intervention? We can have Rwanda and then you, my brother. Thank you.
Thank you very much, moderator. My comment is just is related to how do we coordinate and collaborate in dealing with this economic and organized crime in East Africa. But before going even to East Africa, we need to see if even within our countries, if the way we do coordinate and collaborate is sufficient. Here, I want to tackle on the issue of bureaucracy. Criminals have no bureaucracy. Criminals have no procedures that they do follow. Yet us, we do have those procedures and bureaucracy. So we need to review it. Otherwise, the criminals, they are ahead of us. And it will always be a challenge to do it. If, for instance, as my grandbrother said from DRC, for instance, we are bordering with DRC. A criminal can commit a crime in Goma and just cross the border and goes to Gisenyi or vice versa. And that suspect, we continue to communicate with his or her colleague left in Goma or vice versa. And they do communicate, they share information. As long as we are not quick like they are, there will always be barriers. But when I talk about that we need to review first the procedures and bureaucracy within our countries. In Rwanda, the good experience in Rwanda is the way we collaborate with the other law enforcement institutions. For instance, those who are involved in criminal procedure, in criminal justice, being police, being Rwanda Investigation Bureau, if we need, for instance, an intervention of intelligence services, we no longer write official letters requesting for that. It's just calling the head of that institution. It's just sending a WhatsApp and tell, I need your intervention on this and this and this, and it is done. We no longer go through those bureaucracy and procedure, and it is being helpful. And what it does require, it's just a shift of the mindset. Just an understanding that you are working for the same country. If it's combating crimes, you all have that mandate of combating crimes, and you make things easy. As the criminals make things easy in communicating and collaborating, so we have to make sure that we do the same, first within our countries, but again in our cooperation in East Africa and other countries. You can't imagine how many criminals who were identified in our neighboring countries who got arrested because of those procedures, because of those bureaucracy. You call a colleague, but due to those legal procedures, it has to go through the Ministry of Foreign Affairs, all those procedures, and sometimes it goes to a certain ministry before it reaches the Department of Public Prosecution, and then we are lacking this, we are lacking this. It can take 2 months. Within those 2 months, the criminals have organized already their things and strategized how to escape. So we need to review it. The problem is not the legal framework. If you look at the legal framework that we do have in EAC, there is a very good basis of doing a quick and appropriate cooperation. What we would require would like basing on the existing laws and do a kind of agreement, something that is easy. But again, you can't do it like the prosecution of Rwanda does it with the prosecution of Kenya or Uganda or Tanzania or Burundi without involving also our colleague we work together, that is police and other organs. We have to work together. If there is an agreement between the prosecution of a certain country with another country, there has to be also a cooperation agreement between the police of that country and the police of the other country concurrently, so that you can, as you work together in your country, even dealing with these cross-border crimes, you work together. So my comment, and I will insist on it, we need to review and sit together and see how do we implement the legal framework that we do have so that we can act quick and appropriately. Thank you very much.
Thank you so much, my brother from Rwanda. I think for him, his emphasis is informal contacts. The criminals act informally. Why should we be acting formally? Yet we are prosecutors. We should be entering in the minds of the criminals. So thank you so much. We shall definitely, we have taken note of that. We break down the bureaucracies in our institutions before we even come out here. Thank you. So can we have, I can't see the name from here, but please go ahead. Thank you. You can just introduce yourself, please.
Thank you, Madam Moderator. Let me explain myself in French. Merci, Madame la modératrice. D'abord, je voudrais faire mienne les commentaires que vient de faire mon collègue du Rwanda. Les affaires de bureaucratie dans le traitement des dossiers en rapport avec les crimes transnationaux. Parce que au niveau du Burundi, nous avons eu à faire face à ces défis. Là où on arrête un criminel qui se trouve dans un pays, vous avez des contacts, mais vous contactez un collègue, il vous dit qu'il est en train de faire des arrangements, mais par après, il revient vers vous et il vous dit « Oh, nous sommes en train de regarder ce que dit la loi, oh, on exige ceci. » Et par après, on vous dit « Le criminel est retenu à la police en ayant autant de jours. Si vous ne produisez pas ce document-ci, par exemple, un accord de coopération mutuelle en matière judiciaire, on va relaxer le criminel. » On a déjà eu à faire face à ce défi. Donc, je voudrais aussi qu'on révise le cadre légal pour simplifier les procédures, pour renforcer la coopération dans la lutte contre les crimes transnationaux. Je me réjouis de ce que cette plateforme soit une occasion pour échanger l'expérience et pour apprendre de bonnes pratiques. Par exemple, il y a un problème de recouvrement des avoirs en cas de corruption ou en cas de trafic illégal. Le problème qu'on a évoqué, le problème d'identification des biens. Vous attrapez un criminel, vous le mettez en prison, il est en détention préventive, mais entre-temps, il est en train de s'organiser pour cacher ce qu'il a détourné ou ce qu'il a volé, ou le produit de l'infraction. Alors, je ne sais pas Je voudrais qu'on partage les expériences des autres pour qu'on puisse s'en inspirer. Parce que ça, là aussi, il y a un défi chez nous. Ce problème d'identification pour suivre et recouvrer les biens détournés ou volés. Un autre défi, c'est qui est en rapport avec ce que je venais de dire, c'est le problème d'extradition. Ce problème est en rapport avec le principe de droit international qui dit juger ou extrader. Aut iudicare, aut dedere. Donc, un criminel qui commet une infraction ou un crime, ici, il s'échappe dans un autre pays. Si, par exemple, c'est un Ougandais qui commet un crime au Burundi, il se réfugie dans son pays en Ouganda. Je ne sais pas, plusieurs pays ont ce principe de ne pas extrader leurs nationaux. Alors, il se pose alors un problème. Le crime qui a été commis au Burundi ne peut pas être, du moins, il peut être jugé en Ouganda, mais avec des procédures vraiment très compliquées parce que les preuves ne sont pas là. Vous devez avoir des communications, les preuves, les témoins. Vous comprenez que la procédure va être très, très compliquée pour juger un Ougandais qui aura commis un crime au Burundi, mais qui s'est réfugié dans son propre pays, dans la mesure où on ne pourra pas l'extrader, en vertu du principe qu'un national ne peut pas être extradé. Donc, c'est ce problème-là auquel il faut trouver une solution pour que les crimes transnationaux ne puissent pas rester impunis au regard de ce principe-là qui impose ou que les pays ont adopté dans leur constitution pour la plupart pour ne pas extrader leurs nationaux. Merci.
Okay, thank you so much. Thank you so much for that intervention. Yes, Dorcas. You
Yes. Thank you so much, PG Rwanda. But I wanted us also to discuss or have in mind the fact that when you talk about asset forfeiture and confiscation, we have all agreed that these criminals use very complex banking transactions. And in most cases, when you want bank records, you find this bank is dealing with the other bank as a correspondent bank. So correspondent banking is also used. Now, when you go to bank records and you want to insist that banks must reveal maybe their KYC or the beneficial owners, these are areas that, although we might want to do things formally, we must be very careful from the beginning to do them formally because the banks are very edgy because of their credibility if they are found to have been facilitating money laundering. So with conventional offenses, it will be, but when you're dealing with big institutions like banks, it is good that we review our laws so that we have a legal basis for dealing with them. Secondly, we also must know that economic crimes and asset forfeiture and confiscation investigations sometimes can be very intrusive. And now there is the issue of the intrusiveness of the investigation and human rights. And it is a matter that people are facing all over the world. How far can you go? How formal can you be? Sometimes you might have to need a court order. And when you need a court order, you must have a legal basis for asking for the court order. And then when it comes to tracing, identification, and preservation, we also must have in mind the rights of third parties. Sometimes a case can attract as many as 100 third parties, especially if it's an ongoing concern, a big corporation or a big business which had many clients, and you want to bring it down to confiscate or to forfeit the proceeds and they belong to somebody else. So that is also a bottleneck when it comes to informality that it calls for. All these challenges call for us to review our legislations and make them as flexible as possible as a basis for dealing with these challenges. And finally, we must also talk about civil forfeiture and the abuse of civil forfeiture. Civil forfeiture is very easy. the threshold is very low. It's on a balance of probability. But we have found, for example, in the US, they have found that there was a lot of abuse of civil forfeiture, especially when somebody is not taken to court administratively, they ask you to forfeit or they confiscate what you have. It was found to attract a lot of abuse or excesses from law enforcement agencies. So as East African countries, contiguous countries, we can be as informal as we could, but we should seriously think of having some legal framework to be a basis for our action. Thank you.
Thank you so much, Dorcas. You can have Honorable.
Merci, Madame la modératrice. Je voudrais dire un petit mot au sujet de la question que venait de poser mon collègue du Burundi en rapport avec l'extradition des nationaux par les pays. Lorsque un national commet des faits infractionnels dans un pays et qui se retrouve chez lui ou se réfugie, c'est un principe général de droit qui existe partout. Il existe partout. Mais pour arriver à quelque peu trouver la solution à une situation comme celle-là, c'est justement dans le cadre de ce que nous sommes en train de chercher ici, des coopérations plus proches, entre pays proches. Si nous commençons, vous commencez le Rwanda, le Burundi, entre vous, que vous trouviez déjà une solution à ce niveau-là, c'est déjà un pas. Demain, ce sera moi qui veux aussi me rallier à la solution que vous aurez trouvée et nous allons ainsi avancer. Si nous disons que tout d'un coup, nous puissions partir en groupe, ce sera difficile. Mais si nous commençons par des petits pas, entre deux individus d'abord ou deux groupes d'abord, ça pourra nous aider à aller un peu plus facilement. Je ne pense pas qu'avec tout ce que nous avons dit ici, comme nous avons cité comme lourdeur aussi bien bureaucratique que parlementaire, aller adopter une loi que les autres puissent la ratifier dans leur pays respectifs, ça prend énormément de temps et il est quasi difficile de dire que ça se passera demain ou le lendemain. Donc, si nous y allons par petits pas, nous pourrons finalement arriver à faire des grands pas. Mais il n'y a pas que la difficulté inhérente à cette question d'extradition des nationaux. Vous avez aussi la localisation des biens qui ont été localisés comme étant des biens venant des infractions ou qui sont des produits de l'infraction dans tel pays. Un individu X qui a fait traverser, par exemple, les pointes d'Ivoire, parce que nous sommes dans le contexte de la faune. Il a fait traverser les pointes d'Ivoire au Congo et il les a vendus là-bas, il a obtenu son argent, il a construit un immeuble. Bon, mais l'identification de l'immeuble de la personne qui est citée comme ayant participé à la commission de ces faits infractionnels est encore un peu plus facile. Même si vous êtes chez vous, on peut facilement dire que non, chez nous, sans qu'on dise nécessairement dans un premier temps qu'il s'agit déjà d'un bien provenant du vol ou du produit de vol, ne fût-ce que rien qu'en inventoriant les biens que dispose ces messieurs dans un pays donné, dans le pays où ils se trouvent, en identifiant ces biens, on peut remonter en se disant, bon, c'est bien, à partir de quand est-ce qu'il a acquis? Si c'est un bien, on voit un peu la période d'acquisition de ce bien. C'est un bien qu'il a acquis en 1918, alors que les faits qui lui sont reprochés ont été commis en 1917. On comprend que c'est une période qui est post-crime et qu'il est fort probable que ce bien-là puisse être compris dans les biens qui sont dans le lot des biens que ce monsieur a acquis avec le produit de l'infraction. Donc nous avons ces défis-là. Mais tous ces défis existent effectivement. Nous n'allons pas les rayer en un jour. Non. Mais il faut commencer. Le commencement entre deux, finalement trois, 4, 5 est un peu plus facile que le commencement entre groupes tels que nous sommes ici. Mais c'est déjà quand même quelque chose que nous nous retrouvions comme nous sommes là, ainsi que je l'ai dit. En échangeant tout le temps ces expériences, lorsque je rentre chez moi, je me dis, mais de l'autre côté, il s'est passé ceci, je m'entretiens avec les bureaucrates, je m'entretiens avec les parlementaires, il y en a qui peuvent comprendre ce que je leur ai dit. Certainement que ce ne sera pas tout le monde, mais au moins, ce sera déjà quelque chose qui aura été fait. Voilà un peu la petite contribution que je voulais apporter.
Thank you so much, Honorable. Thank you. Do we have any other intervention? Okay, yes, my brother, Deputy Tanzania.
Thank you very much, moderator. I would like to commend the presenters for the detailed and good presentations on the topic. But I want to comment on one or two aspects. One, if we want to combat transnational and organized crimes, we must make sure that we are joining hands, making sure that criminals do not benefit from the illegally acquired wealth, money, and assets. If we manage to discourage them by tracing and forfeiting all the proceeds of crime, then it will be difficult for us to combat this. I have noted from the presenters, in most of our countries, we have the Financial Intelligence Unit, where they report the suspicious financial transactions. But we are lacking capacities from our investigator to conduct thorough financial investigations, as my sister from Zambia noted. We need to invest in financial and asset investigation. Wherever we receive suspicious financial transactions, then we have to go thoroughly to make sure that we get all the evidence and the details. As my sister from Kenya, Dorcas, said, the burden of proving criminal cases, the standard is high, beyond reasonable doubt. So if we don't have enough evidence, these criminals will escape punishment and will not be able to combat economic and financial crimes. My recommendation, we have to do at least two things. One, we invest. As member state, we can see how best we can build capacities of our investigators and the prosecutors in financial and economic crimes, especially in tracing the money and the assets, the proceeds of crime. And two, we have to see how best we can cooperate, even if we need to amend some of our laws, as my brother from Rwanda commended, to reduce the bureaucracies. While we are engaging in a formal procedures of going through the diplomatic channels, at the end, the criminals are not there. So my recommendation through this conference, maybe we see how best we can build the capacity of our investigators and prosecutors in the financial related crimes, especially the transnational and organized crimes. Thank you.
Thank you so much. Thank you for that intervention. I think the rapporteurs must be noting that as well. Then my sister from Zambia, Mozambique, please.
Muito obrigada por nos dar a palavra.
Em primeiro lugar, gostaríamos de manifestar o nosso agrado e solicitar os organizadores pela escolha dos temas. Quando nós recebemos o convite para esta reunião, recebemos com muito agrado, tendo em conta os temas que estão em discussão, porque vai nos permitir colhermos e bebermos a experiência dos nossos colegas magistrados do Ministério Público aqui presentes para melhorarmos a nossa intervenção relativamente aos temas que são aqui apresentados. Nós trouxemos na manga algum aspecto que tem a ver com a recuperação de ativos, porque a nossa lei foi aprovada o ano passado, o que significa que ainda temos pouca experiência relativamente a esta matéria. Gostaríamos, por isso, de...
Recording in progress.
Gostaríamos, por isso, de perguntarmos aos nossos colegas que experiência é que nos podem transmitir em relação à recuperação de ativos, porque no combate à criminalidade não basta descobrir o criminoso, é necessário também identificar e recuperar o ativo proveniente dessa criminalidade. A pergunta não é dirigida apenas aos panelistas, mas quem puder também intervir do lado de cá, da plateia. Então, a pergunta é dirigida a todos os colegas. Esta é a intervenção que eu tinha ao pedir a palavra. E, mais uma vez, obrigada por nos ter concedido a palavra para apresentarmos esta nossa preocupação. Obrigada.
Thank you so much, our sister from Mozambique. Is there any other intervention? I am just over by 2 minutes only. Is there someone monitoring online? If we have any questions online? I think we have exhausted. I'll just, okay, the last one. Thank you.
Thank you. I'm Pierre Shindano from Democratic Republic of Congo. I'd like to speak in my official language. Bon. Ma question s'adresse à Dorcas Oduor. Vous avez parlé de la confiscation civile et de la confiscation pénale dans votre exposé. Ça fait partie de une partie de votre exposé. Et vous avez même dit, parmi les critiques, il y a des gens qui considèrent la confiscation comme une affaire particulière. Et vous avez dit que ce n'est pas une affaire civile parce que c'est l'État qui est en train de confisquer les biens contre un particulier. Et la confiscation pénale ou la confiscation criminelle qui est opérée à la suite d'une procédure pénale, avec comme défi, il faut apporter la preuve que le bien provient de l'infraction. Bon, généralement, pour les pays c'est plus aisé de parler de la confiscation pénale et de la confiscation civile. Mais pour les pays romano-germaniques comme les miens, on ne peut pas concevoir une confiscation en matière civile. Pourquoi? Parce que dans nos constitutions, la propriété est pour utilité publique. C'est l'État qui peut exproprier après une juste réparation. Alors, C'est vrai que pour les pays anglophones comme le Canada, en Afrique, je connais aussi l'exemple de l'île Maurice, ça donne l'avantage d'être plus facile parce qu'on ne vous demande pas de prouver que ça provient de l'infraction. La question qu'on vous pose est simple, de prouver l'origine, par exemple, de tel bien. Si vous êtes un salarié, on vous demande, non, à partir de votre salaire, de prouver si vous pouvez payer. Quand vous donnez vos listes de paye, on constate que c'est en deçà. Et qu'elle fait comme en île Maurice. Là, le juge va prendre seulement une ordonnance de confiscation. Une ordonnance de confiscation, et la confiscation est civile. Contrairement en matière pénale, où il faut prouver que les biens proviennent d'une infraction, et vous avez la charge de la preuve, même si, avec l'évolution, on admet actuellement le principe de renversement de la preuve. C'est comme ça que chez nous, on continue la charge du renversement de la preuve. On vous demande de prouver l'origine. Alors, j'ai voulu faire ce commentaire pour vous rejoindre. C'est un commentaire, ce n'est pas une question que je pose comme telle. Parce que quand vous avez dit non, c'est l'État contre un individu, ce n'est pas des civils. Bon, dans nos pays, comme la propriété privée est garantie par nos constitutions, l'État ne peut pas prendre les biens. Pour exproprier, il faut une cause d'utilité publique et l'indemnisation doit être préalable. Alors qu'au pénal, confiscation pénale, ça suppose une infraction qui doit être prouvée. Et l'origine du bien doit être infractionnelle. C'est juste un commentaire, ce n'est pas une question.
Okay, thank you so much. Yes. Okay, I agree. You see, criminal confiscation is criminal based in that even if somebody has been convicted, at times, depending on the property being forfeited and confiscated, the process of confiscation now follows civil procedure process. But we have cases where there is no accused person, the confiscation is against the asset. That is why we are saying it is civil, because there is no accused person before the court. And when we go civil without the accused person, the procedure from the beginning is the civil procedure. And I do agree with you, because those are some of the challenges of civil confiscation. Some people are saying that we are reversing the burden back to the accused person, to the owner of the property, because in that case, it is you to prove that the property is not tainted. And that is why most of the time it is used for instruments of crime. In this case, we are saying it is the property that has committed the crime. So for example, if your vehicle was used to transport terrorists, you cannot deny when they have blown up at a hotel. It is the vehicle that transported the terrorists. If it is your lorry that transported ivory from your home to the port, you cannot deny because it did. The thing is there justification, or did you know, constructive or direct knowledge? So I do agree with you that there is a challenge all over the world on the application of civil forfeiture. And there is also a challenge of the terminology, civil confiscation, civil forfeiture, civil procedure. For us, we know that all confiscation, whether civil or post-conviction forfeiture, you follow the civil procedure to give room to third parties and interested parties to also come and lay their claim before the court, because sometimes the asset is owned by more than one person and there are competing interests.
Okay, thank you so much, Dorcas. I think that brings us to the end of this session. Thank you so much. I think now we are not going the same way we came into this room. We know that challenges in following the money. We know the importance of asset recovery. We know that in some instances we have to do informal contacts. In others, we must follow the formal way, otherwise then we get problems in court. I don't know, Nick, you wanted to make any comment? No. Okay, thank you so much. So I want to thank the panelists. You've been very, very great. You made my work very, very easy. Thank you so much to each of you, and thank you for the listeners. At least you were not, I didn't see anyone dozing. Everyone was awake, so it is an interesting topic. And also thank you for the online people who are following. Thank you so much. I think I hand over here I just overshot by only 9 minutes. Thank you so much. Thank you.
Thank you so much, Lady Justice Jane Francois Oduor. I've learned